Yes, ma'am.
How do you respond to the concern that by having brought a federal lawsuit now, when other people interested in the same cause have avoided doing so for the past 5 years, you're taking the chance that whatever happens in the lower courts, the U.S. Supreme Court may definitively rule that there is no federal constitutional right to same-sex marriage, whereas they might not do that if people waited a little bit longer.
Well,
how do you respond to
well,
that concern?
there's several responses to that. One, the California Attorney General has admitted that Proposition 8 is unconstitutional. Therefore, the individuals that stand before you today are suffering unconstitutional injury every single day. To tell them to wait is unacceptable. When someone's losing their constitutional rights, their civil rights, their fundamental rights, their right to be treated equally under the law every single day, telling them to wait is not acceptable. Secondly, the individuals and groups for whom we have great respect and admiration, and we appreciate their point of view. Those groups, by and large, have filed a brief supporting the outcome that we're seeking in this case. We're working with them every single day. We respect them. We hope and expect and anticipate, and I'm quite sure that they will be participating with us in one form or another and helping to reach the goal that we hope to reach. Thirdly, when it does get to the United States Supreme Court, we expect to win.
Can you say why?
Why? Because Proposition 8 is unconstitutional. The United States Supreme Court has held repeatedly that the right to marry is fundamental. It's the most fundamental and important relationship that's recognized by our Constitution. It's a part of the right to privacy. It's a part of a right to liberty. It's a part of a right to association. And when we treat people unequally with respect to the exercise of that right on the Constitution on the basis of sexual orientation, that is unacceptable. And that is another basis for why this law is unconstitutional. The Supreme Court of the United States said 123 years ago, in a case involving someone who wished to run a laundry in San Francisco, that the right to equal protection of the laws is the right to the protection of equal laws. Proposition 8 is not an equal law, and that's one of the reasons why the United States Supreme Court will hold it to be unconstitutional.
So would this case only deal with California same-sex couples being allowed to marry, or in your mind, would it open the door for same-sex marriages in all 50 states?
Well, it would depend upon how broadly a court ultimately decided the issue. California has some very, very unique facts, and we are focusing in part on those unique facts. One of those facts is that the California Supreme Court recognized that under the California Constitution, prior to its amendment in Proposition 8, citizens of California had a fundamental right to marry without being discriminated against on the basis of their sexual orientation. The California Supreme Court has already held that. Then the voters, by amending the Constitution, took away that right. There are cases under the United States Constitution, one of which involved Colorado a few years ago, in which the Supreme Court of the United States said taking away a constitutional protection from a class of individuals in the state violates the United States Constitution. And when that Supreme Court of the United States made that decision, they were citing and relying on a case from a number of years ago. Some of you might even remember Proposition 14 in the mid-60s in California, in which the United States Supreme Court held that taking away the right to equal protection in housing, which the California citizens decided to do in that case, was a violation itself of the Constitution. So, in answer to your question, the California situation is unique because the facts come in a certain way where a right acknowledged by the Supreme Court of California has been taken away. On the other hand, if the court decides to go more broadly, it could have an effect on individuals who are discriminated against on the basis of their sexual orientation in other places. I won't try to anticipate how the courts will ultimately rule in this case.
It sounds like the court wants to do a full-on trial, and the attorneys aren't necessarily thinking of it as a full-on trial with witnesses and everything else. Is that your impression that that's what the judge wants?
Yeah, I do think that the judge, this is a highly respected judge, the chief judge of the Federal District Court in the Northern District of California. And as he pointed out, I am a trial judge. This is what we do, is we have trials here. We adjudicate facts. We're not an appellate court. He recognizes and appreciates the importance of a solid factual foundation for whatever he ultimately decides. We agree with him that he is wise and he is thorough and he's conscientious. What we're saying to him is that we don't think that may necessarily be required, because many of the facts we can agree upon, many of the facts maybe already have been addressed by the California Supreme Court or the United States Supreme Court, but at minimum we were saying today, and my opponents were saying also, that we can narrow the issues down, and the scope of that trial may be considerably narrower, and if it's considerably narrower, it won't take as long, it can reach a conclusion more expeditiously, and so we're going to work with this judge. He is a superb judge, and he will do the right thing, and we will try to help him in whatever way we possible to give him the foundation and the facts necessary for him to do what he thinks is important for his job.
And this is the last question here.
Is it to your advantage, to the couple's advantage, to have a full trial, to have a full trial with testimony before the case goes up?
Well, I think that what we think is important for the judge to have the facts necessary to make a sound decision. And we want him to get those facts. We may be able to give him those facts in agreements that the parties reach. We may be able to give him those facts in the form of decisions that have already been made by the California Constitution. We may have to have some kind of a trial where there's cross-examination. I don't know. I do think, and I said this today, that we think that it's so manifestly clear that Proposition 8 is unconstitutional. Even the state of California admits that it won't be necessary to have a full-blown, extensive trial. On the other hand, we want to do it the best way that we possibly can, in the interest of justice, in the interest of my clients, and in the interest of people similarly situated wherever they may be.
And there was concern, same question, but there was concern when it was thought that you might go up on appeal on the denial of an injunction, that you would be better off with a solid record and more information.
Well, the point we wanted to make, and we said at the very beginning, that we would make that decision when the time came. The point that we made with respect to the preliminary injunction motion, it gave us some options. It gave us some options to consider what we might do at different stages of the case. The option that we've got now before us is to make the point, and we made the point, that individuals are being damaged every single day. It is intolerable in this country that we allow admitted constitutional violations to continue. On the other hand, we made with that motion the point that damage is occurring, and whatever we do, it needs to be addressed promptly. The judge agrees, our opponents agree.
Thank you, Mr. Olson.
Can we hear from either of the couples about their